Texas doctors get new guidance for when a woman can legally get an emergency abortion.
At the end of the day, it is the physician who is going to render that final recommendation and that judgment on how to act on a given scenario.
But not everyone is satisfied with the decision. We look closer why some believe the rules could put women at risk.
That one alert at the right moment for the right person might save a life, so why not?
Years after its creation, an active shooter alert remains silent. Why one lawmaker says it comes down to a change in procedure.
It's time to stop ignoring this issue or dismissing it as someone else's problem. As you can see, this can happen to any of us.
Stories from victims calling for new steps to block explicit images created by AI. Now a Texas senator spearheads a new bipartisan bill.
Produced from the Capitol in Austin and airing statewide, this is the award-winning State of Texas.
Hello and thank you for joining us. I'm Monica Madden, in for Josh Hinkle. The Texas Medical Board unanimously approved new rules giving guidance on when doctors can perform emergency abortions legally in the state. It's an effort to clear up any confusion over what is and isn't allowed, but the board did not provide a list of conditions of when doctors can provide abortions, warranting criticism from some. Here's a look at those guidelines. When and how doctors can perform emergency abortions in Texas has been contested for years.
Then they've established a whole set of such severe penalties that it's created this chilling effect, and no one wants to be the test case. I don't.
On Friday, the Texas Medical Board adopted new guidance for how physicians should interpret the state's abortion laws, but acknowledged their limitations.
There are certain things that we can address, and there are certain things that we ultimately don't feel that we have the authority to address.
The rules outline how the board will look into alleged illegal abortions. They added guidance reiterating a Texas Supreme Court ruling that said doctors do not have to wait until a medical emergency is imminent before terminating a pregnancy.
If a woman's life is in danger, there is no uncertainty there.
The panel refused to list specific medical exceptions to the law.
The concern with a list is, what if a situation arises when something is not on that list?
Joining us now are attorneys and lobbyists Steve and Amy Bresnan. They are the attorneys who originally wrote the petition to the Texas Medical Board. It sparked this entire rule change, and I'll preface that both of you were not lobbying on behalf of a specific client when you wrote this petition to the Texas Medical Board, asking them to clarify when doctors could provide an abortion to women under the medical exceptions clause. So first and foremost, I just kind of want to highlight, what was your original goal when you filed this petition, and do you feel like you got anywhere near that goal?
So our original goal was to obviously make the situation better with whatever tools we had at the time, because the legislature is not going to be in session until January. The Texas Medical Board was really the only avenue to seek immediate relief for women who find themselves in this situation. So we wanted to make sure that any improvements could happen immediately with the Texas Medical Board. That was our original goal. Where do we think that we are now? There have been some slight improvements. However, we are disappointed. We don't think that doctors will feel any more comfortable providing abortion care where it's necessary under the statute, which means that women are they're not as safe as they were before or after these rules were adopted.
Now, I want to talk about the documentation provision. Of course, now doctors, after performing an emergency medical abortion, will have 7 days to, fill out this documentation explaining the reasons for that and, what they thought, why it was justified. However, one of the controversial provisions that was kind of being discussed during all of these board meetings, Steve, you found was still in there somehow.
Yes, it was a documentation provision under the proposed rules that would have required the physician to document whether there was time to transfer to a, quote, higher level of care in order to avoid an abortion. None of that appears in the statute. It has nothing to do with the abortion exceptions. They took that out of the documentation part and put it over into the part where what a disciplinary panel should consider. At the meeting, they said they had taken it out, but it's over now. It's in the disciplinary part. That's an upgraded, if you will, standard. It's a lot less of a being implied as it is being made more substantive and direct. That's moving backwards.
What does the path forward now look like for you?
Consulting the lawyers who work actively in the administrative procedures law as to whether the law requires this rule to be republished, so there'd be more public comment on it.
We do think that this rule is required under statute to be republished because there were substantial changes, and under statute that means that they have to give the public notice and seek comment.
One of the good things they did was said she doesn't have to be at death's immediate door, and so that'll give physicians a little more space to operate in. But we think that those things combined are substantive enough changes. The public got no notice that this transfer provision was going to be made more substantive and less just a matter of documentation. It's important that we not talk about that in esoteric, legal terms either. This means delay. If the physician has to find through any means necessary where a higher level of care, whatever that means, might be, and then get her there by life flight, by car, by train, by whatever, you're talking about delay. Somebody with a life-threatening condition who's already met the standards of the statute then has to wait
in order
while this physician tries to meet this implied duty. It's a serious matter that has practical application for patients.
And based on what some of the stakeholders have written over the years, it's clear that the transfer provision says in order to avoid an abortion to a higher level of care. In normal speak, what that means is it's going to cost more. So they're going to transfer a woman to a higher level of care, keep her on antibiotics, bed rest until her pregnancy is far enough along that they can perform a C-section on a non-viable fetus, which is extraordinarily more expensive than an abortion.
All right, that's our time for now. Amy and Steve Bresnan, thank you so much for your time today.
It's really just about protecting my child.
A new bill taking aim at pornographic AI imagery. How the story of one Texas family is pushing one lawmaker to take action. Did you know there's an active shooter alert? Despite mass violence events across the state, an alarm has never been sent out. A state lawmaker breaks down the confusion over the procedure and the change she wants to see over the system. Senators in Washington announced a plan to tackle intimate images posted online without a person's consent. And there's a new twist. Some of those revealing images are deep fakes. The bipartisan proposal would force big tech companies to take down pictures, both real and those created by artificial intelligence. Washington correspondent Vinay Simlot looks closer at the legislation and why it's personal for one Texas teenager and her mom.
A new year and a new school.
I was so excited for high school, but this totally just threw off my year.
Brought a new problem for Elliston Berry.
And it was really scary to even go to school, just out of fear.
The Texas teen says someone used artificial intelligence to make a pornographic image of her.
That he didn't take someone else's nude images and put their faces on them. Instead, he took their actual bodies using AI to make the images look even more real.
On Tuesday, Ellis and her mom joined Senator Ted Cruz on Capitol Hill as he introduced the Take It Down Act.
It's really just about protecting my child.
The bipartisan proposal would make it a crime to publish those pornographic photos, whether they're real or AI. It would also force tech companies to take them down within 48 hours.
If you put online a scene from The Lion King, that'll get pulled down almost immediately.
Senator Cruz says tech companies know how to take content down, but Ellis's mom says she didn't have any luck with the app where her daughter's photos circulated until Senator Cruz's office intervened.
Just non-responsive. Nothing.
This election year, Senate Majority Leader Chuck Schumer says the Senate is trying to target fake AI-generated pictures.
And we're going to look for a way to move those bills forward.
It's rare bipartisan agreement.
It's just hard to go to school
on an issue that could impact any family with just one share. In Washington, I'm Vinay Simlot.
Cruz introduced the legislation along with Minnesota Democratic Senator Amy Klobuchar, but it's not the first bipartisan Senate bill aimed at this problem. Illinois Democrat Dick Durbin introduced similar legislation earlier this year. His bill would allow victims of non-consensual deepfakes to sue people who created, possessed, or even distributed the images. Durbin has not been able to get a floor vote on his bill. The issue of explicit AI images got a lot of attention earlier this year due to Taylor Swift. Deepfake images of the pop superstar went viral on social media, and backlash from fans led companies to crack down. The platform X temporarily blocked searches of Taylor Swift's name and assigned teams to remove the explicit images. The platform cited its zero-tolerance policy of non-consensual nude images. The impact to the pop superstar helped fuel calls for legislation to protect victims, including from President Joe Biden. When a holiday celebration turned deadly, some expected a system created 3 years ago would keep them informed. We found it's never been used at all. Now a Texas representative vows to make a change in procedure. Preventing disaster. Texas City is considering major safety changes after our investigation reveals cars crashing into hospitals across the country. We look at how it's getting attention from policymakers at the local level and in Washington. A celebration to commemorate the ending of slavery for black men and women in Texas turned into chaos in Round Rock. Police say a fight between two groups ended in gunshots, leaving 2 people dead and 14 others hurt. As people mourned the loss, police looked for anyone responsible. Days went by and the community there asked a question: why didn't they get an alert for an active shooter? The state has an active shooter alert system that's designed to warn people who are close to an active shooting situation through their phones. It was first filed by Representative Brooks Landgraf of Odessa after a mass shooting there killed 7 people and hurt another 25 back in 2019. However, Investigator Avery Travis discovered this system was not activated during the deadly shooting at Round Rock's Juneteenth event. In fact, it hasn't been activated at all since its creation in 2021. Avery sat down with Austin area Representative Vikki Goodwin, who wants to see it used more frequently.
As a lawmaker who watched this law go into effect, what's your reaction to hear that in a situation like this, such a large event, that activation was not implemented?
I think we pass laws to make people safer, this one in particular, to let people know if there is an active shooting event going on so that they can take precaution. So for me, it's really tragic that we're not using this alert system that we put into law to make people safer. So nobody was aware that this shooting was going on. Some people said they thought it was fireworks at first, but then they saw people were running. So I think it would have been helpful for an alert to go out so people are aware. That might change their behavior and might save lives.
And this isn't the first time that you've been outspoken about wanting to see this utilized more. Talk to me about that incident here in Austin.
Yeah, there was an incident in Austin where, again, I thought the alert system should have happened. There was a shooting on a school property. The man didn't die. He was taken to the hospital. The shooter left, though, and hours later killed other people in South Austin, Southwest Austin. If the alert had gone out, the woman that was walking her child down the street might not have been out on the street if she had known there was a shooter on the loose. Again, it was up to the Austin Police Department to make the call to ask for the alert system from DPS. They chose not to. They felt like it was an isolated incident, but it was, in my mind, a shooter on the loose in our community, and I think community members ought to know. I know we do see a lot in our, the Amber Alerts. We get a lot of Amber Alerts, and so we feel like, oh my gosh, another Amber Alert. But yet, that one alert at the right moment for the right person might save a life, so why not?
Representative Goodwin believes law enforcement agencies could implement narrow parameters around how and when they use active shooter alert system. Law enforcement agencies do have to make a formal request to DPS for this kind of alert to be sent out to the public. The incident has to be in their jurisdiction and verified through a preliminary investigation. They also have to be able to identify the shooter's last known location, and they have to determine that an alert would actually help people in the area. DPS says since 2021, it has not received any requests for activation from Texas law enforcement.
I think you have good investigative journalism that brings to light a significant safety issue.
Following a deadly car crash into an Austin hospital, our team revealed hundreds of similar crashes all across the country. Now, one by one, Texas cities are taking notice and taking action, looking into safety requirements that could prevent disaster. I'm investigator Matt Grant. An update to our reporting is coming up. An update to our Preventing Disaster investigation as crashes continue at medical centers across the country.
How did it happen? How did it happen?
The latest in Pennsylvania and Ohio in the past month, and another just days ago at a medical center in Kentucky. Now added to a list we recently revealed showing more than 300 similar crashes in the last decade. A list that's also grown in Texas since our first report to around 100 as our team uncovers more crashes here at home too. Following our investigation prompted by a deadly crash at St. David's North Austin Medical Center,
I had several productive conversations today with my colleagues, and that is moving forward.
Austin and these other Texas cities where hospital crashes have happened are considering new safety policies. This after we shared our findings with League City, Navasota, and College Station. All now looking at possibly requiring hospitals to have security barriers, called bollards, at their entrances to stop cars from driving through.
He was like on the floor with this trash and debris, just covered in blood. I just saw the whites of his eyes just like looking up at me.
College Station City Council member Bob Yancey watched our investigation and is now looking into a bollard ordinance.
This is an issue that I just had no idea the severity of until I saw your reporting.
Crashes have happened in his city before, twice. In 2017, a truck drove through this hospital's ER doors. It's since installed nearly 20 bollards. And the woman behind the wheel of this vehicle told us she suffered a medical episode when she drove into the lobby of Baylor Scott & White Medical Center in January. Why weren't there bollards there?
That's a good question.
That's the same hospital where Yancey was once chairman of the board.
It's just not an issue that, ever really occurred to me. And I think in a lot of ways, this is how public policy evolves. I think you have good investigative journalism that brings to light a significant safety issue.
6 months later, his former hospital has not installed bollards. Instead, using the same stone blocks a police report said the car pushed to the side.
I now know from your research they're inadequate to the cause, and only through a properly engineered bollard can vehicles be stopped and these injuries and or fatalities be avoided. If I had had the benefit of your reporting when I was serving as chairman of the board of our local hospital, this, I guarantee you, would have been a topic of discussion.
Experts tell us this momentum could lead to broader safety changes.
If you have multiple cities in a given state who start doing their own ordinances, states get a little nervous about that and they'd like to standardize it.
Baylor Scott & White did not answer any of our questions, only saying it has a number of safety and traffic protocols and looks forward to working with elected officials.
First of all, I want to thank you for what I believe is the public service that you, Matt, and your team have done with this story.
The changes College Station and other cities are considering, we've heard, would likely only apply to new hospitals. But what about existing facilities? Experts tell us cost is a big factor, but that federal grants could be an option. We reached out to the federal agencies that hospitals and safety might fall under. We either didn't hear back or learned those specific grants only exist for nonprofit hospitals. But we also learned funding or any federal action could require Congress getting involved. After we reached out, we know the office of at least one Texas congressman is reviewing our findings.
This suggests to me a concern that should be raised about federal facilities to ensure that they're safe, not just for those who are in the building as government employees, but for all those who might approach them.
So like a VA or like a government building, that's something you would look at to make sure that those buildings are properly protected?
Absolutely. I do think what you found will give rise to my asking the General Services Administration, which is responsible for most federal buildings, to take a look at them and see what dangers might be posed, and I will pursue it with GSA as a result of your report.
The very next day after speaking with us, Congressman Lloyd Doggett sent this letter referencing our reporting to the General Services Administration in this U.S. region to check on bollards at federal facilities. We'll keep you updated on any next steps. Until then, catch up on our complete coverage in this ongoing investigation online by clicking the link in the State of Texas story on this station's website. Matt Grant, State of Texas.
Thank you, Matt, and thank you for joining us for State of Texas. I'm Monica Madden. We'll be back next week to bring you an in-depth look at Texas politics.